Hello, I'm Dave Steinfeld, a Florida Bar board-certified business litigation attorney. This means I'm recognized as an expert in business litigation law in the state of Florida. This video you're about to watch is from a talk I gave entitled A Primer on Business Litigation Law. The topic of this video is what a business can do with the judgment it obtains and the potential impact that a judgment can have on a business. This video is not intended to provide you with legal advice, but to give you a general understanding of this topic. After you've had an opportunity to watch the video, please take a look at other videos and articles on my website, www.davidsteinfeld.com. Thanks for watching. I'd like to talk to you about the end result of a lawsuit, which is oftentimes a judgment. What does a corporation do when it obtains a judgment, and what can it do? Judgments can come either from a trial, or they can come from pre-trial procedural mechanisms such as a default if the other side doesn't answer, or summary judgment if the facts are so crystallized in a case that a court can decide the matter without a trial. When a company obtains a judgment in its favor, it can execute on that judgment by legal means against the assets of the judgment debtor. When a third party obtains a judgment against the corporation or the company, that judgment creditor, the holder of that judgment, has similar rights against the company. On the first matter, what can a company do? What can your business do with a judgment? You can execute that judgment against the assets of the business. You can attach assets that are held by the business. You can garnish property that is held by third parties, and you commonly see this with banks, garnishing bank accounts because the bank holds the property for the judgment debtor. You can also, in certain circumstances, replevin property. If you're not familiar with these terms, all of these are handed down to us from Old English common law, and there are writs that the sheriff executes on, and the court directs the sheriff to take this action with those writs of attachment, writs of garnishment, writs of execution. There are certain abilities that a judgment holder, a company that has a judgment, can have even in situations where there may not be assets to go after immediately, because judgments have a certain lifespan. Additionally, if parties do not cooperate with the court in the judgment execution process, those parties can find themselves liable for the actions that they've taken, and can also find themselves in a lot of trouble with the court. One example of this was a matter that I had of a company that loaned money to someone, and then the individual did not pay on that debt. My client, through my efforts in court, obtained a judgment. The individual, who was on the west coast of Florida, refused to come to the East Coast for any hearings, refused to attend any depositions in aid of execution, or to provide any information on what assets were there. After a number of times of going through this process, the court, to enforce the judgment that the court had issued, finally issued a writ of bodily attachment, which is something similar to what you would commonly call a bench warrant. This individual was arrested by about 6 sheriff deputies at the individual's place of business and put into the transport system in the state of Florida, and it took 5 days to make a 2-hour journey across the state, because the process was such that they had to go to different cities and transport through the state. By the time that that individual was brought before the judge to explain why the person had defied the court's order and had not shown up to the subpoena issued by an attorney, that person was brought into court in an orange jumpsuit, in leg irons, in hand irons, and had not had a shower for 5 days. And the judge's comment simply was, "I think the next time Mr. Steinfeld tells you to show up for a deposition, you probably will." That's the power that our courts have. That's not something that gets thrown around very carelessly, but that is the power that a corporation can have in enforcing a judgment that it obtains in its favor. Conversely, when a third party obtains a judgment against a business, that third party has certain rights to go after the assets of the business, which can include the shares of the business or the membership units of the limited liability company. We've just recently had a change in our LLC statutes, in the limited liability company statutes, that restrict what a judgment creditor can and cannot take of the member's interest in an LLC. The limitation is that for a multi-member LLC, more than one person, a judgment creditor cannot take an individual's membership interest. The limitation on the execution of a judgment now is just to a charging order of whatever monies that individual would get from the business. That's what the judgment creditor can get. However, with a single member LLC, where it's just one person that owns the business, a judgment creditor can literally take over the company by taking that member's interest. A perfect example of this is a situation that I encountered not too long ago, just north of here. My client was a private money lender and had loaned about $12 million to a developer who was going to build a golf course community with a commercial shopping center next to it. The real estate market didn't actually support, in the end, this development, and the borrower defaulted on these loans. During the course of several years, these loans had been rolled up into different notes and different mortgages. Somehow, the commercial parcel was inadvertently allowed to fall out of these mortgages and wasn't subject to the final mortgages. I, fortunately, did not have anything to do with the drafting of the mortgages. I only came in to foreclose those mortgages. When I foreclosed the mortgages, we were able to take back all of the residentially zoned property, but we didn't have the commercial property, which made the whole project. So the plan that I came up with was to obtain a deficiency money judgment against the individual who had personally guaranteed the mortgages, which is authorized by our Florida statutes, and then take that money judgment and execute it on the individual's membership interest in the business that held the title to the commercial property. Through that, my client was able to take over the business and all of its assets, including that commercial parcel, and recover the commercial parcel by executing against the member's interest in a single member limited liability company.